Hello, I am Dr. Debashish Buddhar. I am Assistant Professor of Law and I am working at National University of Study and Research, NUSRL, Ranchi. Today, I will be discussing about the module. The name of the module is Basis of Criminalization. Basis of Criminalization. Basis of Criminalization is a module which is exploring the interface between jurisprudence and criminal law. Now, we will be discussing the basis of criminalization in the age of legislation. Basis of criminalization, it is there since time immemorial from the very beginning of the civilization. But so far as basis of the criminalization is concerned, we are living in the age of legislation. So, as a background information, I will start with the beginning of the civilization. At the beginning of the civilization, at that point of time, legislation was not there. So, how criminalization started its journey from the beginning? So, let us have a quick look over the same. So far as basis of criminalization in the ancient period is concerned, the first started with the instance. So far as instance is concerned, it is the first happening of a particular action or omission by some subjects of the society which was not liked by others. So this is first instance of the basis of criminalization. So what happens in criminalization on the basis of instance? A particular action, say for example culpable homicide. This has happened, one person is killed or destroyed by another person and the society or surrounding did not like. So what will happen? The particular person will face the wrath of the community in a way or other. This is the instance. For the first time, a crime has happened and the response of the society is demonstrated. Thereafter, when this instance is continued in practice, so when a particular instance is continued in future, at that point of time it was followed as a matter of practice. So what is practice? Practice is something which is followed, which is following the first instance as a matter of ritual. So in this way, instance is followed by practice. At later point of time, this practice, when people understood that this is the normative order, in that case practice is at later point of time graduated to usage. After some point of time, this usage will usually graduate to custom. So what is the difference between usage and custom? Usage refers to a practice which is a matter of practice only. So here the legal compulsion is yet to come. On the contrary, custom is something where the subjects of the society has conviction over the normative order that this custom has the status of law. And at later point of time, legislation has come into effect. Today, for last few centuries, we are living in the age of legislation. So before legislation, usage and custom, and thereafter legislation, the way this transition took place, we need to understand this before we enter into the operative part of criminalization. So usage and custom, here the technical difference lies in the belief. So far as usage is concerned, it is the following of earlier practice as a matter of rituals. So here, so far as law or legal element is concerned, that is absent. But in contradistinction to that, so far as custom is concerned, here there is a strong belief or conviction in the minds of the subject that custom has the status of law. Practically from here, the journey of law in technical sense of the term starts. So far as legislation is concerned, there is intricate relation between custom and legislation. If we take care of the Hindu Marriage Act or Indian Penal Code, etc., we will see that earlier what was as part of customary law, at later point of time, by and large, with several exceptions, ramifications, etc., we have inherited customary law as the legislative law or practice. And in that way, so far as legislation is concerned, it is the finer version of the customary law. And now we will start the criminalization and its basis. So far as legislation, criminal legislation in particular is concerned, this is the expression of the sovereign, as Austin told, as positive jurisprudence told. So this is the expression of the sovereign will so far as criminalization is concerned. But criminalization is a project, albeit social and political project, which we will see is ridden with ramifications of several components of this increasingly complex society. Now, let us start with the basis of criminalization. Defining crime. This is the beginning point of the basis of criminalization. How we will define crime? So, crime refers to a behavior condemned by the law as state policy. So, behavior is very important component of crime. So, basis of criminalization practically starts with behavior, and behavior in the eye of law must be delinquent or deviated from the established norms or accepted norms. The second point, this deviated behavior must be associated with a guilty mind, but sometimes even without guilty mind is also possible. So, let us introduce the definition of crime. So, defining crime, let us start with this point, that what is crime. Usually there are several components of crime. Crime refers to behavior condemned by the law as state policy. So far as law is concerned, here I am using the law as an instrument, as a social and albeit political instrument in the hands of state. So behavior is usually a subject matter to be condemned by the state on behalf of the society, because here the state is acting as trustee of the society. As a matter of state policy, there is a policy making process, and law is part and parcel of the policy making process. And by a complex process, law is made, criminal law in particular, to condemn a particular behavior as deviated and departed from the established or accepted or desired normative order from the society. So this is a very first component of criminalization. Second, so far as behavior is concerned, deviated behavior that must be associated with guilty mind. So behind behavior, a presence of a guilty mind, or in technical sense of the term, mens rea, it is the second component of the basis of criminalization. So far as basis of criminalization is concerned, the deviated behavior must be associated with guilty mind. So presence of guilty mind, or mens rea in technical sense of the term. This is an important component for criminalization, but at the same point of time, guilty mind may not necessarily be available for criminalization in all the cases. At a later point of time, we will discuss about the same. So far as third component is concerned, criminalization usually takes place in course of public life, and at times in cases of private life also. So public life, here we need to understand public life in technical sense of the term. What is public life? Wherever interaction between two or more subjects in the society are involved, that is called public life. So in that way, sometimes, many times, private life is part of public life, in the sense that within four walls of the house, whatever is happening, in case if there is any deviation from the established normative order accepted by the society, especially in course of two or more individuals' interaction, in that case, private life will be construed to be public life for criminalization. Domestic violence is one important illustration to this end. So, by public life, the way usually it is called for, not necessarily that public life will be construed outside the four walls of the house, even within the four walls of the house also, private life may be construed as public life. Fourth component, the criminalization must be supported by provision for punishment or penalty by the law of the land. So, here endorsement of law is very important, because criminalization may take several routes. There may be moral criminalization, there may be social criminalization, there may be legal criminalization. So, here in law courts usually we take care of legal criminalization. Besides, there may be other areas of criminalization like social criminalization, ethical criminalization, which are well established in practice, but until the same is endorsed by law, we will not usually in the study of criminal law, we do not take care of this as criminalization. So, in this way, these four components usually constitutes several parts of criminalization. But here there is another issue remaining, which is decriminalization. So, criminalization is usually a relative concept. Sometimes at a particular phase of the social development something may be criminalized, but before that phase it may not have been criminalized, or even after the phase it may be decriminalized. So, criminalization has to be understood in the context of a particular time and space. So, in that way criminalization must be defined. At later point of time we will start with theorizing the crime or criminalization per se. Now, let us define the components of criminalization. First, we have described behavior. What is behavior? Let us try to understand behavior as the first component of criminalization. Usually, behavior includes several components like action, omission, amendment. There are others also, but let us first explain action. Criminalization includes action in the sense that there must be some action which is criminalized on the basis of delinquency, on the basis of deviation from the accepted, well established or desirable social norms. But what is action? Is it an act per se or something else? So, let us try to understand this in the light of the second component of behavior. Second component is omission. So, here action does not include action only, that is positive action, but negative action, omission in technical sense of the term, that also includes action, in the sense that somebody is getting drowned in the pond, and if somebody else who is expert in swimming and capable of saving life at that point of time takes resort to omission, in that case under the law of the land it may be taken care of as action for the sake of criminalization, but usually omission is weaker side of action. So, usually in the sense, and so far as criminalization of omission is concerned, it has wide variance from society to society, from state to state, from region to region. Coming back to the third point, abatement. Abatement is something which may be action or omission to instigate, to prompt other people to commit through action or omission to such offense which is prohibited by the law of the land. So, abatement is also inclusive of criminalization, and it is part of the criminal law of the land in India also. Fourth point is common intention. So far as common intention is concerned, whether it is action or omission, common intention involves several people, at least two or more people, to commit something through action or omission with common intention in mind. So, here we are coming back to the guilty mind discourse once again. So, if with common intention two or more people commit something through action or omission, in that case that will also fall under the jurisdiction of common intention. Fourth is over. Now, let us take care of fifth point, criminal conspiracy. Criminal conspiracy, as we have seen it under section 120B of the Indian Penal Code, criminal conspiracy is in furtherance of common intention. In furtherance of common intention, if there is anything conspired by two or more people, and if it is done with criminal mind or guilty mind or mens rea, in that case that may be also booked by the criminal law of the land. Last but not the least is unlawful assembly. So, in case if there is a limit on the assembly declared by the state for a particular time in a particular space, in that case unlawful assembly, whether or however there is common intention or criminal conspiracy, it is a point apart, but unlawful assembly per se, it may be unlawful and criminalized by the state. So, all these are criminalized by the Indian Penal Code 1860. Now, we are coming to the second point, that is guilty mind. What is guilty mind? Guilty mind is mens rea as a component to put charge of criminality on the person concerned. So, here person concerned mind or state of mind is very important, and the same constitute a rationale for on the basis of a legal maxim. The legal maxim goes like this: that actus reus non facit reum nisi mens sit rea. The English meaning may be read in this way, that an act does not make a defendant guilty until without a guilty mind. The Latin maxim may be read it in English: an act does not make defendant guilty without a guilty mind. So, this is a general rule, but there are exceptions also, in the sense that there are cases, exceptional cases indeed, which does not require guilty mind to be present for making something, action or omission criminal. So, in that way, let us take care of the exception to the guilty mind. There are two ways we can think of exception to the guilty mind. One is the case of strict liability irrespective of culpa. So, in case if there is strict liability in the law of the land, in that case culpa or the guilty mind is not required as such, because actus reus is enough to hold the accused guilty in those cases irrespective of the presence of guilty mind to this end. So, thus culpa may be presumed to exist ipso facto until proved otherwise. So, in that case the onus of proof will lie on the other side, the prosecution, to prove the presence of guilty mind against the accused person. So, mens rea or guilty mind may not be the necessary component for criminalization. Without mens rea also, as per the basis of strict liability principle, we can constitute criminalization. But there is another facet of exception in the form of general exceptions out of duress. So far as duress is concerned, this is also a technical term. Duress provides for a waiver from criminal liability in spite of actus reus with the mens rea required by chapter 4 of the Indian Penal Code 1860. So, in this way, so far as section 76 to 106 of the Indian Penal Code is concerned, all these constitute a wide array of general exceptions on the basis of duress by which the criminalization may be waived from the accused on the ground of general exceptions. So, general exceptions from prosecution out of criminality, this is also an exception to the guilty mind. Now, let us come back to the third component of public life. What is public life? A very wide concept, because like public good, public interest, public order, etc., public life or public sphere as per Habermas, it is an elastic concept, elastic enough to get extended to otherwise private affairs, as we have discussed earlier also. Thus, if circumstance requires, in that case, intimate affairs as part of otherwise private life may and does get construed as part of public life, and more so in criminal law of the land. So, here the paramount importance is public tranquility or peace and order in the society. So, in that sense, public life may get extended to any extent to take care of public tranquility, because chaos and order, these are construed as two binary opposites. At later point of time, we will come across all other binary opposites also. So, in that way, public life, it may be extended to any extent in public interest. Again, like public life, public interest went undefined in the law dictionary. Let us come back to some other allied areas of criminalization. Criminalization talks about many things which requires the involvement of some other allied issues like penology and victimology. While criminology takes care of the criminal, penology talks about the art and science of penalty. So, penology refers to the systematic study of penalty or punishment and includes the principles related to first, assessment of the crime concerned, second, proportionality with the harm committed, and third, last but not the least, curative and corrective measures thereof. So, assessment of the crime concerned, that constitutes the first and foremost criteria of penology, because on the basis of assessment, other matters will be taken care of at later point of time in course of judicial process. So, second point, proportionality. Proportionality takes care of the judgment part, that the judges must take care of the magnanimity of the crime, so that the penalty or punishment must not exceed the extent of crime or the harm committed. Last but not the least, curative and corrective measures. So, unlike earlier time when the criminology was driven by retribution, since time immemorial until modern age, criminology or criminalization was taken care of on the basis of retribution. But here modern criminology, modern penology is driven by the curative or corrective measures. Here, rather than retribution, the underlying idea of criminal law at present is correction of the criminal concerned. So, in that way, penology takes care of the jurisprudence of judgment, sentencing, which will lead the criminal to correction. And now, let us take care of victimology. What is victimology? Victimology refers to the paradigm shift of focus from the convicted to the victim, and in case of his demise, the dependent of the victim concerned. So, here there is a relatively newer subset in criminal law, victim, his injury and satisfaction through restitution, reparation, compensation, etc. So, in that way, victimology talks about the victim. The judicial process according to victimology must be victim centric rather than the criminal centric approach as we have traditionally followed. Now, so far as approach to criminalization is concerned, criminalization is governed by two rational routes. One is consensus approach and another is conflicting approach. Consensus approach is based on a democratic or conformist attitude which takes care of consensus among the members of the society so far as the decision of defiant attitude or criminalization is concerned. On the contrary, so far as conflicting attitude is concerned, This talks about a constant struggle between the dominant force and the dormant force so far as criminalization is concerned. Usually, conflicting approach believes that there is always a struggle between the dominant discourse and dormant discourse to decide upon the delinquency of behavior in the society. And accordingly, conflicting approach believes that until the dormant approach overpowers the dominant approach always conquers in terms of criminalization. So, criminal law or the criminal jurisprudence, criminology, penology, etc., all these are decided by the dominant interest, and always the dominant part of the society tries to perpetuate their interest through criminalization. This is also one way of looking at it. So, here you will find that in the conflictive attitude there is a constant dialectical approach by which the action or omission is criminalized, whereas the first approach, that is the consensus approach, that is made out of consensus. So, here lies the technical distinction. So far as taxonomy of criminalization is concerned, crime is thereby divided in two ways. One is violent crime and another is non-violent crime. Violent crime is associated with physical hurt, whereas non-violent crime is associated without physical hurt. So, in that way, non-violent crime takes care of the socio-economic offences usually. Their characteristics getting poles apart, they need different treatment in terms of, so accordingly, violent crime and non-violent crime, they need different approach in terms of penology and victimology also. Now, so far as the technical variants of penology is concerned, now so far as the technical variants of the criminalization is concerned, it may be of societal, economic, political, juridical, cultural, ideological. So, all these components taking together, this forms the basis of criminalization. At the same point of time, there are other varieties called as variants or variables of crime, like social status, economic opportunity, political polarization, judicial construction, cultural orientation, ideological position, etc. So, together all these contributes to the study of criminalization. At bottom, criminalization is value judgment, and this value judgment is taken on the part of dominant group interest in the given time and space, and to spearhead dominant public interest. Thus, value judgment is relative and subject to change with regime change. Last but not the least, a very important component lies in criminalization of criminalization. So, before that, let us take care of the binary opposites taken care of by criminalization. Criminalization is governed by a set of binary opposites on the basis of value judgments like correct incorrect, fair unfair, good evil, just unjust, right wrong, etc. So, in that way, the latter side is usually getting criminalized in the absence of the former. Now, coming back to the criminalization of criminalization, the end of crime therefore has transcended a paradigm shift from actual harm to virtual hurt. So, the basis of criminalization with the passage of time, it has transcended from actual harm to value hurt. Rather than actual harm to get inflicted, what matters is the value system of the given time and space that ought to get hurt. The last point, which is all the more important in modern context, that it is subjectivity of crime. At bottom, there lies politics of dominance, as we have indicated earlier, and the same plays critical for such value judgment. Thus, value judgment getting subjective crime has had no set model and is subject to change with the passage of time. So, how to take care of criminalization in a democratic society? So, criminalization of crime must follow these paramount concerns through these principles. With topsy-turvy in power arrangement, irrationality in courts of criminalization may and does attract criminalization in itself. Thus, criminal lawmakers themselves turn criminals after the fall of their regime. History is ridden with plenty of illustrations to this end. So, the fundamental principles which must be followed in a democratic society for remedy of this malady lies here, that 1. Institutionalization of criminalization, 2. Broad-based policy making on crime, 3. Elimination of individualized opinion, and 4. Lawmaking in line of public opinion. At the same point of time, criminalization may get vitiated by populist paranoia to gross detriment of justice. So, while policy making, the lawmakers should be aware and take care and caution of the maladies of criminalization as well. With this, we conclude the session on the module basis of criminalization. Thank you.